Welcome to The Print. My name is Apoorva Mandhani and here's the quickest list of 11 important judgments passed in 2023. First on this list is of course the judgment on demonetization. The year began with the Supreme Court on 2nd January upholding by a 4:1 majority the Narendra Modi government's November 2016 decision to ban Rs500 and Rs1000 currency notes. Second is, of course, the Supreme Court's judgment on Article 370. On 11 December, the court unanimously upheld the abrogation of Article 370 of the Constitution, which gave special status on the erstwhile state of Jammu and Kashmir. However, the Supreme Court did not look into the validity of the bifurcation of the erstwhile state of Jammu and Kashmir into two union territories through a law in 2019. This was in view of the statement given by Solicitor General Tushar Mehta during the hearing that statehood would be restored and that the UT status was temporary. Third on this list is the Supreme Court's judgment on marriage equality. The Supreme Court on 17th October ruled out legalizing same-sex marriages in India. A 5-judge bench led by Justice D.Y. Chandrachud declared that the court cannot tweak or read into the Special Marriage Act, which is the law governing interfaith marriages in India, to grant legal recognition to marriages between queer couples. The court left it to the Parliament to frame a law for extending institutional acknowledgement to such relationships, adding that the current legal framework does not support such a union. Fourth on this list is a 5-judge bench decision, Constitution Bench decision of the Supreme Court that allowed the Arvind Kejriwal-led government to exercise its executive as well as legislative authority over the officers of various services, including those who are not recruited by it and have been allocated to Delhi by the Union of India. This was essentially in furtherance of the Delhi government versus LG debate, but pertained specifically to the area of services, and this included the authority to transfer and post officers within the government, frame service rules for them, or undertake any other measure for governance purposes, including passing a law in the Legislative Assembly. The Delhi government, of course, won this one, but the win was short-lived because within days the centre promulgated an ordinance creating a new statutory authority to handle transfer and posting of bureaucrats in the national capital. The ordinance now creates a new statutory authority which is called the National Capital Civil Services Authority. However, the Delhi government took this ordinance to the Supreme Court as well, and its petition was referred to a Constitution bench in July this year. Fifth on this list is another 5-judge Constitution bench decision of the Supreme Court on the political fallout in Maharashtra last year following differences in the Shiv Sena between groups owing to allegiance to the Chief Minister Eknath Shinde and his predecessor Uddhav Thackeray. Now, just to give you a bit of background, because I know this is a more complicated, there's a more complicated history to this conflict. Shinde essentially, this is last year, Shinde broke away to assert his own faction supremacy and became the CM in July 2022 with the BJP support. Lots had happened in the state then, and the Supreme Court now ruled this year that former Maharashtra Governor Bhagat Singh Koshyari was not justified in asking then Chief Minister Uddhav Thackeray to face a floor test in the wake of the crisis in the party, which was the undivided Shiv Sena. The Supreme Court asserted that a floor test cannot be used as a medium to resolve internal party disputes, and also said that the Speaker's decision to appoint a whip from the Eknath Shinde group was contrary to law. However, the bench did not restore Thackeray as the Chief Minister of Maharashtra because he did not face the floor test and had tendered resignation in June 2022. Shinde is now the Chief Minister of the state. The court directed the Speaker of the Assembly, however, to decide on the disqualification of MLAs who switched to the Shinde faction, leading to a split in the Sena. Now, before I go on to the 6th judgment on this list, just to let you know, all the articles and the videos that we've made over the years on all of these important judgments, the links to these articles and videos will be added to the description. So for more context, if you want to know more about these judgments, please go check out the links in the description. Now, the 6th on this list is related to the governor's powers. Throughout the year, in fact, we saw several centre-appointed governors having found themselves at crossroads with the elected state government, especially over the governors not giving their assent to crucial bills passed by the state legislature. In November this year, the Supreme Court held that if a governor decides to withhold assent to a bill, then he or she has to return the bill to the legislature for reconsideration. This was in a case involving the Punjab government and the state governor. Seventh In March this year, 5-judge Constitution Bench of the Supreme Court modified the process for appointing members of the Election Commission of India. The court held that a committee comprising the Prime Minister, Leader of Opposition and the Chief Justice of India will advise the President on these appointments. However, in order to overturn the verdict, in August this year introduced the Chief Election Commissioner and other election commissioners Appointment, Conditions of Service and Term of Office Bill 2023. This bill said that the CEC and the ECs will be, that is the Chief Election Commissioner and the election commissioners will be appointed by the President on a recommendation of a selection committee which will have the Prime Minister, a Union Cabinet Minister and the Leader of Opposition or Leader of the largest opposition party in Lok Sabha, essentially taking the CJI out of the equation. The bill was passed by the Rajya Sabha as well as the Lok Sabha in December this year. 8th on this list is a judgment, very crucial judgment on the concept of living wills or advance directives, which was introduced in India by a Supreme Court judgment in March 2018. Just for a bit of background again, a living will or an advance directive is a document that a person can execute in advance, explaining their wish about withholding or withdrawing medical treatment in case they are terminally ill or in a situation in which they are undergoing prolonged medical treatment with no chances of recovery and cure. So now the 2018 judgment had recognized the right to die with dignity as a fundamental right and laid down guidelines for terminally ill patients to enforce the right through an advanced medical directive for a future situation, like I mentioned, in which they reach a point of no return. 6 years later, in January this year, the Supreme Court made the process less cumbersome by modifying the existing guidelines. For example, it did away with the role of the magistrate in executive and implementation of an advance directive while also simplifying the composition of the medical boards, determining whether life support systems can be withdrawn and setting time limits for these boards to take such decisions. For the 9th judgment, I'd like to bring in a High Court judgment in this list. This is the Allahabad High Court judgment passed on 19 December, holding that a suit filed in 1991 over the Gyanvapi mosque is not barred under the provisions of the Places of Worship Special Provisions Act 1991. Now, the suit in this case was filed in 1991 by the devotees in the name of Swayambhu Lord Vishweshwar, demanding that they should be allowed to renovate and reconstruct their temple because it was built at a site of a temple on Aurangzeb's orders. The case will now be heard. There was a long legal battle. Of course, the suit was filed in 1991 and now the Allahabad High Court has sort of given a green signal for the suit to move forward. Again, this has also had a complicated history since 1991 and I'm going to add the links to the description. But essentially, the case will now be heard by the Varanasi Civil Judges Court, which has been directed by the High Court to proceed with the matter expeditiously and conclude the proceedings within 6 months. Now, the 10th on this list is an October judgment. In this judgment, the Supreme Court asserted that Union and the states are bound to ensure that the practice of manual scavenging is completely eradicated. So, this was an important judgment in which the court issued a slew of directions. Among other things, the court enhanced the compensation payable for sewer deaths to 30 lakhs from the earlier 10 lakhs and said that the minimum compensation for such victims suffering from disability shall be 10 lakhs. The court also directed the union to take appropriate measures to ensure that such a practice is completely eradicated in a phased manner. Now, 11th and the last on this list is, again, I'm going to take you back to January. In January this year, the Supreme Court clarified that its 2018 judgment decriminalizing adultery would not impact court-martial proceedings initiated against all the personnel serving in the armed forces for adulterous conduct. So essentially, the 2018 judgment was in itself a landmark judgment, but the court's clarification was equally important because it clarified that the decriminalization of adultery would not impact court-martial proceedings against the armed forces in which the question of adultery might be raised. That's all I have for you for now. These are the 11 important Supreme Court and High Court judgments for you that were passed in 2023. Like I mentioned, again, just a reminder, I've added all the links to our stories and to our videos to the description of this video. So I hope that would be helpful for you. Thank you so much for watching.